Good evening, Anand all. On behalf of our team APLC and on my personal behalf, I welcome you all for this seventh webinar of the series. I am Advocate Anand Kumar, practicing in Delhi High Court. The topic of today's webinar is overcoming the dilemma of saving the businesses and jobs, the stake of employers and also the employees and the workmen in this lockdown, by our special speaker, Advocate Anushka Bhardwaj Arora. She is practicing in Delhi High Court. I sincerely thank you all for this overwhelming response for this event. And as I mentioned earlier in the previous webinars, this only makes us work harder and harder with each passing webinars. We owe the entire credit of this to our special speaker, Ms. Anushka. And as always, we just facilitate by providing a stage for the special speaker to connect with all the participants and vice versa. For all those who are our regular participants, I am sure you might be knowing us by this time. And for those who have come here for the first time, we are Team AP Legal Chambers, a new age law firm in Delhi NCR with a branch office in Chennai. We started our journey in the year 2017 with the vision of providing plenary services to our clients to resolve their legal issues. APLC's portfolio covers a broad spectrum of specialized services, including domestic and international taxation, constitutional laws, IPR, energy laws, commercial advisory, arbitration, and corporate compliances. We started hosting webinars out of our passion for law, and due to the fantastic response from the participants, we are organizing the webinars on every Thursdays and Sundays. Dear participants, we have in our midst our special speaker, Advocate Anushka Bhardwaj Arora, BA LLB Honours, US LLS, LLM in IPR from the National University of Singapore. She is an independently practicing advocate at the Delhi High Court, and she has represented various clients, including top-tier companies, firms, and individuals over IP and commercial matters. She was a former litigation associate with Mr. Neeraj Grover. She has also been an awardee of the prestigious Ramjeet Malani Award for the overall performance and academic excellence. She is currently the Vice Chair for the Young Lawyers Division of the Indian National Association of Legal Professionals, part of the ILSA Philip C. Jessup International Law Moot Court family, and she has been judging oral rounds and memorials at national and international levels. She is also the recipient of the Director General Artillery Education Scholarship, and she is the current holder, she is the past holder from the year 2016 to 18. And she is also the batch topper in the undergrad level. And just for the want of time, I am just cutting the bio with this, and I welcome the special speaker on board. As always, once the special speaker's presentation gets over, we shall be having a segment called APLC's APLC, Ask the Popular Learned Counsel. We have prepared a few questions from our end and would be asking the speaker. I am sure it will be both interesting and informative. As far as this normal session is concerned, as you all are aware, this will be a completely moderated session. And if you are having any questions after the presentation gets over, opportunity will be given to all the participants to ask the questions, and our special speaker would be highly motivated to answer all your questions. And you can leave the questions in the chat box, and all your questions will be answered. And as far as the connection is concerned, I request all the participants to kindly enable mute from their end, and also if possible to disable the video and start asking questions in the chat box. If anything is there, our team is there to assist you. And if there is any problem in between, you are finding any difficulty in connecting or reconnecting, kindly disconnect and connect again, and your permission will be given to join back in this event. So with this, I welcome our special speaker, Ms. Anushka, on board, and she has been kind enough in keeping a regular track of the developments in this event, and she accepted our invitation without any second thoughts. And like you all, I am also eagerly waiting to hear her speech and have a clarity on this subject. Welcome to APLC's webinar, and over to you, Ms. Anushka. Yeah.
Dr. Anand, that was indeed a very warm welcome, and thank you so much for all the kind words. Indeed, it's an honor to be on this platform with the introduction that you've just given me and to our fellow speakers as well. Having said this, once again, a very good evening to everyone. I thank my folks, my colleagues, and my seniors who've joined me today and who would be viewing this discussion later on. And I once again thank everyone for taking out their time and joining me over this live discussion today. This topic today, namely overcoming the dilemma of saving the businesses and jobs, stakes of the owner, workmen, employees in the lockdown, is something which I wanted to speak about since we entered lockdown. However, as now we enter our unlock stage, we must deliberate upon the MHA orders, the advisories, and the employment laws in existence, and how the same were and has to be interpreted in times of pandemics and lockdown. I am Anushka Bhardwaj Arora, and I welcome all of you once again to this platform and for joining me today. I hope everyone is taking due precautions and are safe amidst this pandemic that we are facing. And I once again thank AP Legal Chambers for giving me this wonderful opportunity and to speak upon a topic which I really wanted to have a discussion on. My structure of today's discussion would be more upon addressing queries which the employers and employees might have in relation to survival of businesses or rights of employees, etc. However, the structure that I would touch upon would be a journey from lockdown 1 to unlock 1, deliberating upon MHA orders, advisories during this span. Secondly, I'll be talking about eligible laws which would be handy to analyze challenges met by employers or workforce by interpreting relevant laws. Thereafter, I would be dwelling upon legal aspects involved in such challenges as faced. And at the last, I would be taking up questions first by the organizers and then by the participants. Ever since the emergence of COVID-19 as pandemic, the world has witnessed extensive lockdowns and call for people to stay home as some of the preventive measures against the spread of this disease. The crisis has disrupted the labor market and the sustenance of private businesses, entities that rely heavily on that market. The current level of uncertainty posed by COVID-19 has strained employment relations between private business owners and their employees because employers need to scale down on their losses. And the polar needs to ensure the security of employees' employment and health. Where the world is distressed by the daunting situation created due to this catastrophic outbreak of COVID-19, companies, industries, associations, and their workforces are also facing frantic challenges during such period of disruption. As employers explore their available options, including termination, sending employees on leaves, layoffs, and invoking the force majeure clauses, the legal implications of their actions are called to light. All classes of employees have been affected by the decisions of the employers. The orders and the advisories are wide and subject to interpretations. Labor authorities have been seen taking a very strict view so far. As a result, employers did not have much choice to tackle the situation, and any coercive action against employees was seen as a violation of the DMA, which is the Disaster Management Act, which is punishable with an imprisonment and/or fines before the repealing of the 29th March order of the Ministry of Home Affairs. So the purpose of this discussion is to therefore highlight certain legal aspects which businesses, owners, and employers in India need to consider and have in mind before taking any decisive steps concerning their employees amidst this crisis, the challenges faced by employers and employees during such times, and also the legal remedies which the workmen and employees have in relation to such harsh, unfair actions as taken against him or her. Having said this now, I would dwell upon the journey from lockdown 1 to unlock 1, deliberating upon various MHA orders and advisories that we saw during this span, and I'll try my level best to constrict it to my best of my abilities. So the outbreak of COVID-19 is a global pandemic, we all know. On March 14th, 2020, the government of India declared COVID-19 as a notified disaster. Following this declaration by the central government, several state governments such as Delhi, West Bengal, Maharashtra proceeded to impose a complete lockdown in their states, invoking the 123 years old legislation, which is the Epidemic Disease Act of 1897. In view of the prevailing lockdown imposed by various states, the Ministry of Labour and Employment issued an advisory on 20th March 2020 appealing to all employers association not to terminate their employees or cut wages of its workers in view of the lockdown. The advisory also stated that all employers of public or private establishments are advised to extend their cooperation by not terminating their employees, particularly casual or contractual workers, or reducing their wages. It further stated that if any place of employment is to be made non-operational due to COVID-19, the employees of such units will be deemed to be on duty. Considering the situation prevailing in the country due to the outbreak of COVID-19, the central government, through the Ministry of Home Affairs, invoking its power under Section 10(2)(1) of the Disaster Management Act 2005, and for brevity's sake, I'll refer this act as DM Act, wherever possible, declared a national-wide lockdown on 24th March 2020 with effect from 25th March till 14th of March 2020 in order to contain the spread of COVID-19 virus from further being transmitted. Now, while this country was coming to terms with this national-wide lockdown, a huge exodus of migrant laborers trying to reach their house towns started to take place. Such a mass efflux of laborers increased the risk of spreading the virus, which prompted the central government, through the Ministry of Home Affairs, to issue an order on 29th March 2020, which is a very important order, which we'll see in due course of this discussion. And for brevity's sake, I'll refer this order as Order of 29th March, issued by MHA. In exercise its powers under 10(2)(1) of the DM Act, directing the states and union territories to ensure adequate arrangement of temporarily shelters and provision of foods for migrant workers who had already moved out and got stranded in such situations. The order of 29th March 2020, in order to mitigate the economic hardships of the migrant workers, also directed the states and union government and the union territories to take measures to ensure that all employers, be it the industry or shop and commercial establishments, must pay their wages to their workers without any deduction for the period their establishment are under closure during the lockdown. Consequently, all employees were then required to ensure timely and full payment of wages to their employees or workers, even if no work was carried out or no service was rendered by them during this period of lockdown, and the said establishment was closed. Thereafter, after such orders coming into force, there were certain meetings that were held by associations and factory owners and MDs of companies, etc., wherein they appealed to provide with 50% at least subsidies to workforces. But after the announcement that we all know of the 20 crore stimulus package by the central government, no such subsidies were being provided. Hence, the government, in order to ensure harmony in the economy, had to withdraw the said order of 29th March. And today, here we are in Unlock 1, which is about to get over, issuing certain new guidelines for resumption of services such as malls, religious spaces, etc. Now we dwell upon certain eligible laws which would be handy to analyze challenges which the employers or the employees face in such times of pandemics. We can see reliance being placed on the Code on Wages Act of 2019, the Shops and Commercial Establishment Act 1958, the Industrial Dispute Act 1947, the Payment of Wages Act 1936, the Factories Act 1948, and various notifications by the Ministry of Labour and Employment dated 20th March and 23rd March, and of course, not forgetting the 29th March order issued by the Ministry of Home Affairs. So these regulations would be deliberated hereinafter, understanding the types of employments that we would see and we would talk about. So before we understand these certain legislations, we also need to understand what are the types of employments that we'll be deliberating upon and what are the types of employments which are present today. We can classify these types of employment broadly in two ways. One can be public service and one can be private service. When I say private service, I mean workmen including contract workers, casual workers, migrant workmen including sales, promotion employees as defined under Section 2D of Sales Promotion Employees, Condition of Service Act 1976. And also not to forget a very important aspect of a private service sector, the employees which draw more than 10,000 rupees per month. Talking about the public service engagement. So as far as the public service is considered, the same is governed by the central government or the state government or the DOPT guidelines issued or other codified norms or the service laws. In employment rules relating to public service, a due process is followed. Although the payment of the workers in the public service is usually secured as a due process is followed, and the employer, which is a public service entity, is required to act as per the statutory or constitutional obligations. However, yet in the present situation, owing to revenue deficit, several state governments have taken the policy decision to deduct the remuneration of the employees. For example, the government in the state of Telangana, in the wake of the state's financial situation amid COVID-19 and dwindling revenues, has vehemently decided a huge pay cut for its employees, ranging from 10 to 75%. According to the proportion of cut, there shall be 75% cut in the salaries of the chief ministers, state cabinet, MLCs, the MLAs, state corporations, chairpersons, and local body representatives, and a 10% cut in the salaries for the class 4 retired employees and for all the public sector undertakings, the institutional employees. So at this juncture, the government of Maharashtra had also announced a 60% cut for all ministers and representatives of local bodies, whereas a cut of 50% in the salaries of class 1 and class 2 employees was seen. Now talking about the private service. When I said private service, I meant firstly workmen including contract workers, casual workers, migrant workers, and so on and so forth. It is significant to mention that the Ministry of Labour and Employment issued a circular dated 23/2020, requiring the employees and the establishments not to terminate the employees and not to cut the wages of the workers. And to quote this order, all the employers of public-private establishments are advised to extend their cooperation by not terminating their employees, particularly casual or contractual workers, from job or reduce their wages. The said circular was only advisory in nature and hence it was not really enforceable. However, thereafter, the Ministry of Home Affairs issued the order dated 29th March, where under the central government constituted the National Executive Committee under Section 10(2)(1) of the Disaster Management Act 2005, as I just mentioned, and issued an order which inter alia included payment of wages by the employers to the employees of any industry, enterprise, commercial enterprise. There is no need to dwell into and quote the said order because the said order has already been explained by me in the prior of my discussion. So further on, we dwell into the aspect of Section 51 of the Disaster Management Act 2005, which is basically a penalizing section for any non-conformity of the orders or the directions issued by the government. Furthermore, the said act has also an overriding effect embodied under Section 72 of the Disasters Management Act, which provides the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for for the time being in force or in any instrument having effect by virtue of any law other than the Act. Furthermore, under Section 71, it states that no court except the Supreme Court or the High Court shall have the jurisdiction to entertain any suit or proceeding in respect to any such direction. So these were some aspects which we saw about the dealings with respect to pandemics and under public service, or the dealings of the few prevailing laws under the private service, whereupon we touched upon the workmen, or the contract workers or casual workers and migrant workmen. We'll also touch upon many other private service personals in the due course of this discussion. But before that, I would be, I humbly request if one of the speaker could mute thank you so much. Sorry for the small disruption. Next, we finally touch upon the important aspect of today's discussion, which is the challenges faced by employers and employees and the legal aspects involved in situations of lockdowns during such pandemics. Here we would talk about challenges faced by employers and employees during pandemics, as I just mentioned, and at the same time, look into how to overcome the same by analyzing relevant laws to it. First and foremost challenge which the nation faced during this lockdown was to interpret these orders and advisories which were passed by the government, especially the order 29th March of the MHA. These challenges revolved around the interpretation of the category of employees in an industry or shop and commercial establishment to which the MHA order applied. So for better understanding of the same, it's pertinent to again and to quote the MHA 29th order, and I quote and read, "All the employers, be it in the industry or in the shops and commercial establishments, shall make payment of wages of their workers at their workplaces on the due date without any deduction for the period their establishments are under closure during this lockdown." So based on the above extract from the MHA order, it is abundantly clear that the same applies to workers who are drawing wages at their workplaces. It also states that this is applicable only to those establishments that were closed during the lockdown. Since the MHA order did not define who is a worker, it is important to place reliance on various legislations that define the term worker, and also those legislations that define the term wages, and also to workers to whom these wages needs to be paid to arrive at a correct interpretation of these MHA orders. The Code on Wages 2019 Act, which I mentioned in the beginning, is an act of the Parliament of India that consolidates the provisions of 4 labor laws concerning wage and bonus payments and makes universal the provisions for minimum wages and timely payment of wages for all workers in India. However, this act, though published in the official gazette, will only come into effect on a further date as notified by the central government. Until that day, the existing regulations shall continue. The Payment of Wages Act 1936, and for brevity's sake, I'll refer to the act as POW Act, defines what is wage. The preamble of the POW Act states that it is an act to regulate the payment of wages of certain classes of employed persons, whereas it is expedient to regulate the payment of wages to certain classes of these employed persons. This makes it clear that there are other classes of employed persons to whom wages need not to be paid. Wages as per section 2, 6 and 3 of the POW Act clearly state that employers shall pay wages to their workmen engaged in factories, industrial or other establishments governed by the Act. Most corporates and employees engaged in industries, factories and other establishments, but performing managerial, administrative, supervisory functions as stated above, shall not be governed by the POW Act, as a matter of fact. Further, the POW Act also clearly states under section 1(6) that it is applicable upon such of class of employees whose wages do not exceed to more than 24,000 per month. The term worker thereafter is defined as per Section 2(1) of the Factories Act 1948, and which means a person employed directly or by or through any agency, including a contractor, with or without the knowledge of the principal employer, whether for remuneration or not, in any manufacturing process or in cleaning of any machinery or premises used for manufacturing process, or in any kind of work incidental or connected with the manufacturing process, and so on and so forth. There is mention of wages to be paid to employees in two other legislations, namely the Industrial Disputes Act of 1947, and for brevity's sake, I'll refer it to as ID Act, and the Shops and Commercial Establishments Act 1961, the SCE Act. It is thus imperative to understand who is eligible to earn wages under the ID Act. The ID Act mentions that under Section 2RR, wages means all remunerations capable of being expressed in terms of money, which would, if the terms of employment expressed or implied were fulfilled, be payable to a workman in respect to his employment or of the work done in such employment. Thus, wages under ID Act needs to be paid only to a workman. The term workman is defined as per Section 2S of this ID Act. The term workman applies to people performing manual, unskilled, skilled, technical, operational, clerical, or supervisory work employed in an industry, but shall not include any person employed in a managerial or administrative capacity, and also doesn't include any person who in such capacity or not earns more wages exceeding to 10,000 rupees. Further on to the SCE Act, which is the Shops and Commercial Establishment Act. And each state, as you all know, has its own Shops and Commercial Establishments Act with specific sets of rules and regulations. This particular act states that wages need not to be paid to employees as per the POW Act. As per the POW Act, employees who are earning more than 24,000 per month are not governed under POW Act, and hence are not required to be paid wages under this said MHA order, which we had seen and now which is repealed, of the 29th March 2020. Furthermore, Section 2CC of the ID Act defines closure to mean the permanent closing down of a place of employment or part thereof. India being a common law country, our laws are subject to strict interpretation. It can also be safe to interpret that this does not apply to an establishment that has work from home or is partly working or is not under closure through other arrangements. Finally, workplace shall have the meaning within the ID Act if such workplace falls under the definition of the industry or undertaking therein. Else shall be either a shop or a commercial establishment under SCE Act. So it is clear from the preamble and definitions of terms under the various legislations as I just discussed, as well as the MHA order, that the employers were mandated to pay only wages to eligible employees. Based on the above definitions and meanings under the various statutes, it is clear that wages are required to be paid only to the following class of employees, namely employees of an industrial establishment that are workmen, employees of shops and establishment that are non-exempted by the SCE Act of the respective state. Now, the next challenge which we may see is a challenge by the employer to overcome a unilateral termination or an amendment of employment contract as above. So based on this analysis of employees in the above mentioned challenge and the interpretation of the MHA order, if the employees were earning wages, they could not be terminated in the light of the MHA order and were to continue to be employed and paid until the lockdown continues or until such time prescribed by the government in this regard. No unilateral amendment to an employment contract is possible unless it is specifically stated in the employment contract between the employer and the employee. If the employment agreement or the manual does not set out a unilateral power to the company, it will need to obtain the employee's consent, implied or express, before such a change is effected, which affects their employment terms or the conditions made. We now look at the next challenge. Challenge which can be faced by employee if they are not earning wages under the POW Act. Are they eligible to receive salaries during the lockdown? The various Indian labor legislations provide protection only to those employees that earn wages under the POW Act, irrespective of whether they work in factories or industries or shops or establishments. For all other employees who does not earn wages under the POW Act, their relationship with the employers are entirely governed by the employee the employee handbook and or their employment agreement. So there is no statutory mandate on the companies to pay salary to these employees that are not earning wages. The companies may also defer payment or alter payment terms if there are such businesses conditions that may cause loss to the company or lead the company into insolvency. This may be achieved by communicating in writing to the employees and also by obtaining either an express or an implied consent from their employees. So this draws our attention to employees now drawing more than 10,000 per month. Next in line comes the issue relating to the payments of salaries or remuneration to the employees drawing salary of more than rupees 10,000 per month, and thus they neither come under the definition of workmen nor governed by any other legislation relating to the labours. Such employees are governed by the employer and employee contract agreement, which governs the terms and conditions of their employment. In the present pandemic situation, the clause relating to force majeure will also surface and become the underpinning in most of the contractual cases. Pursuant to such force majeure clauses, employers may be released from their contractual obligations to pay workers or continue their employment if their contract contains a force majeure clause. And when I say force majeure clause, I mean an extrinsic event such as a pandemic which renders the employment agreement impossible to perform. But now, in an absence of a force majeure clause from the contract agreement, Section 56 of the Contracts Act 1972 comes into the picture. This would be applicable in the present situation of outbreak of pandemic and cessation of work, which is relating to the doctrine of frustration, which entails the law of discharge of contract by reason of supervening impossibility of the act agreed to be done. Under force majeure, the performing party is excused from performance or discharge as a supervening circumstance which has made the performance of the obligation temporarily or permanently or wholly or partially impossible, or is entitled to suspend performance or to claim extension of time to this performance. Furthermore, in the present scenario, where the world is still at a standstill axis due to coronavirus pandemic, it is most likely that the performance under the contract will be delayed. Hence, the invocation of a specific force majeure clause as per a contract entered into between the employer and employee, and which includes outbreak of epidemic, would absolve the employer from payment and therefore from fulfilling its obligations under the contract. It is pertinent to state that the Ministry of Finance also released an office memorandum wide number 1804-2020, dated 19/2/2020, to the effect of clarifying the meaning of force majeure, provided in the Manual for Procurement for Goods and Services 2017, wherein it is embodied, and I quote, "It should be considered as a case of natural calamity, and force majeure may be invoked wherever considered appropriate following the due procedure as above." The next challenge that now we look into are the challenges faced by employees who were not required to be paid wages as per the MHA order. Can their contract be terminated? Yes, employees who are not required to be paid wages under the MHA order and whose services do not fall under the ambit of the MHA order can be terminated by the employers. Termination of such employees will have to be carried out as per the employment contract duly executed between them and or as per the SCE Act of the relevant jurisdiction where the employee is located. While the termination advisory is not binding like the wage order, terminating employees or contract workers during the lockdown would definitely carry risk and is avoidable by employers. Any adverse steps could result in employees going to the labor authorities, who could view this as defeating the purpose and the intent behind such orders. Labor authorities have been extremely active across the country and have been issuing notices to the employers, advising them not to take coercive steps against the employees, such as SpiceJet, etc. Retrenchment or termination is also an option that the employers have with them post this lockdown. For workmen, retrenchment would need to meet the following requirements under the Industrial Disputes Act, the IDA. Certain things need to be followed, as to a prior notice of either 1 to 3 months needs to be given. Payment of retrenchment compensation at 15 days average pay for each completed year of continuous service needs to be done. Notice to the relevant state government if there are more than 100 workmen needs to be done. And compliance of certain standing orders needs to be done, if any. Termination of other employees is governed by the Shops and Commercial Establishment Act of each state and ordinarily requires employees to be given 1 month prior notice. Having said and deliberated upon these challenges, we now turn on to the next challenge, which is if the above category of employees that I just mentioned, who are employees not required to be paid A wages as per the MHA order, or whose services don't fall under the MHA order, can these set of category of employees' employment be terminated in totality? And what are the steps and safeguards that an employer and an employee may take by doing such into consideration? It is recommended that the employer, before making a decision to terminate, shall at all times ensure that they are in compliance with the provisions of termination under the employment contract and the SCE Act of that state where the employee is located and engaged in services, as the case may be. When the employee is terminated, it is also highly likely for the employee might disagree that your interpretation to me that I am not a wage worker is not accepted and you cannot terminate my employment. Hence, it is very important to be very careful while drafting the said termination letter, and the words in these termination letters need to be very carefully worded. The employee may also approach the COVID-19 employee helpline and use the helpline as a forum to register a complaint and seek relief against the employer for non-payment of wages from the government. During this pandemic situation, there is high probability of the administration to take such stances and scenarios as very conservatively and strictly interpret the said situation. There is a strong possibility of the Labor Department overstepping its jurisdiction and to entertain such complaints from employees sympathetically. They might also recommend such employees to go to the police to lodge a complaint, and directing the employer to pay wages to the complainant employee on compassionate grounds. So in such eventualities, I advise that the employer pays the employee salary under protest with a disclaimer that the company reserves the right to recover the same from the employee after this COVID-19 crisis is over. It is recommended that companies adopting these measures create appropriate termination letters with carefully worded termination letters and incidental documentation as evidence for future purposes if the matter ends up in court. By doing so, obviously this measure should assist companies to conserve cash flow in the short to medium term and also to demonstrate compliance with the directives of the police and the labor departments. Now we see the challenges faced by the employees or the employers during layoffs, which is a very important thing to deliberate upon today. Employers could face several challenges in laying off employees. Government permission is definitely required to lay off employees in establishments that employ 100 or more workmen unless the layoff is due to a natural calamity, as just I mentioned in my discussion earlier. So Layoff provisions have not been tested in the context of pandemic in India. And it is not clear whether COVID would qualify as a natural calamity. Although the Ministry of Finance and Ministry of Shipping, Government of India have taken the view that it does. Workmen would challenge layoffs as illegal and could raise an industrial dispute before the labor courts and tribunals. If it is found that government permission was required but not obtained, the employer can also be punished with 1 month's imprisonment and or fines under the Industrial Disputes Act, the IDA. There could also be a dispute as to the payment arrangement beyond 45 days of layoffs if this has not previously been agreed. Furthermore, layoffs appear to be the most attractive option for employers today, given at this time, and given that it has a statutory backing under the Industrial Disputes Act of 1947. That said, this opinion is not available to all employers since layoff provisions under IDA apply only to select establishments, and I make an underline note here. So as per the IDA, layoff is when an employer is unable to give employment to workmen, employees other than managers, administrators, and supervisors come within the meaning of workmen as I defined earlier, on account of certain specified events including natural calamities. So IDA lays down the rights and entitlements of workmen in a layoff. For the first 45 days, workmen are entitled to be paid 50% basic pay and dearness allowance. If the layoff continues for more than 45 days in 12 months, workmen are not entitled to wages assuming such an arrangement has been agreed. Employers employing less than 100 workmen also have an option to retrench workmen after 45 days. If the workman employment contract or the establishment standing order provides more favorable terms, those would indeed be offered to the workman. Now let's look at the applicability of layoffs. Layoff provisions under the IDA do not apply to all employers, but only to industrial establishments, which are the factories, the mines, and the plantations. Further, employers can use this option only where the power to lay off is recognized under the workman's employment contract or the establishment standing order. This is because of the Supreme Court of India has held that IDA does not confer any power to lay off, but only describes employees' right in case of layoff. The citation of the said case is AIR 1976 SC 1775. So layoff provisions generally do not apply to contract workers, but employers who would need to check for exceptions under special laws or contracts with the contractor. For instance, the Bombay Industrial Relations Act 1946 treats contract workers at par with employees, and they are entitled to the same benefits as employees are under the establishment standing orders. For employees other than workmen and contract workers, there is no concept of layoff, and employers would need to obtain consent from the employees for a reduction in wages during this lockdown. After having seen all these challenges, we now turn to the last challenge of our discussion today, which is challenges faced by the employer to get the work done from home. But however, there is a cessation of work owing to which the said employer is financially and economically incapacitated and on the verge of closure owing to the lockdown pursuant to COVID-19. So what remedies does the employer have in such scenarios? Significantly, these statutory legislations like Industrial Disputes Act 1947, Payment of Wages Act 1937, Codes of Wages Act 2019, Contract Labor 1970, Interstate Migrant Workmen Act 1979, and etc. do not envisage any situation or any circumstance of force majeure or intervening circumstance like the present wherein the work is ceased owing to any epidemic or its implications relating to payment of wages. Even vice versa. There is no legislation in India mandating the payment of wages and salaries by the employer in case of forced shutting of businesses for a period of time due to force majeure conditions such as a natural calamity. But the Industrial Employment Standing Order Rules of 1946 specifies the model standing order for governing the employment conditions of the workmen, based on which different industries, after deliberation with its trade union, adopt their own standing orders. One of the model standing order embodies that in case of stoppage of work owing to any intervening circumstance, then the workmen shall not be eligible for any other compensation apart from the payment for the time they have been detained after the stoppage of work. It also provides that if workers are laid off, then the same could be with or without pay, but according to due process. Various industries have their own standing orders, which will govern the payment of wages to workers when work has stopped, which may further aid the employers to take a legally compliant decision relating towards deducting the wages of their industrial workmen in case it is incapacitated to pay the workmen. Thus, in the present situation, if the employer is incapacitated to meet the full expenditure of the payment of wages, then it cannot be termed as illegal on the part of employers to deduct the wages and pay the sustenance amount to the workmen. However, the said measure should be only taken in situations when the employer can very well demonstrate that it is actually incurring a loss. Furthermore, the amendment in Employees Provident Fund Scheme 1952 to aid the employees thus permits withdrawal of up to amount of basic wages and dearness allowance for 3 months or up to 75% of the amount standing to members' credit in the EPF account, whichever is less, in the event of an outbreak of epidemic or a pandemic, which will also help the workmen to sustain. So with this Unlock 1 coming to an end, and COVID-19 cases on a rise, business still being on a standstill, we see that the intent of the government so far has been to secure employees' livelihoods, which is a positive aspect. But the approach has also this approach also needs to be gradually balanced out, considering the aspect of businessmen, factory owners, and commercial impacts that COVID-19 has on businesses. There are already instances where employer consideration have come to be recognized. The Labour Secretary Government of Karnataka, for instance, recently withdrew its earlier orders directing employers not to terminate employees or to deduct wages during the lockdown, based on representations made by the employer associations. The Bombay High Court also recently passed an order stating that employers would be entitled to deduct wages for employees who voluntarily remain absent from work despite being in areas that are not subject to restriction. The extension order marked the intent of the Government of India to permit recommencement of businesses and operations in a gradual manner, and in this situation, employers would require some freedom to take measures in respect of their employees in order to mitigate the commercial and economic aspects of COVID-19 on the businesses. With the relaxations proposed in the said extension orders and etc., perhaps the time is now right to reconsider the approach, to have a balanced approach overall, wherein the demands of the employees and the challenges met by the employers are also kept into check. And also keeping in mind the 20 crore stimulus package which the government announced, wherein the said package included 30 crore of collateral-free automatic loans, 20,000 crores of subordinate debts, 50,000 equity infusions through funds of funds, MSME change, the change in the definition of MSME, global tender restrictions, and e-market linkages along with the funding of different states. We've seen significant developments in which the government is also trying to create a bridge between employers and employees, or be it workforce or employers. And having said this, I hope we all definitely try on our end also, we being we being in different capacities and powers, and definitely try to control situations and have a harmonious outlook towards the said situation. Um, Also respect certain advisories which are being issued in interest of the nation from the government of India. With this, I would love to wrap up my discussion and open the floor for question and answers, if any. Uh, my time limit is till 7:30, and this half an hour, I love to utilize the same in having a constructive discussion. Of course, to my best of my best abilities. And thank you so much once again.
Yes, that was a quick and lucid explanation. Moving on to the next question. So personally, I think handling workman-related matters on pro bono basis is the least we can try to do from our end as lawyers. So, what is your take? Do you concur, or do you have a different opinion on this?
Absolutely. I feel that working pro bono for workmen or workforces is definitely at least a lawyer could do in his capacity and having a limited knowledge. And personally, I have been definitely trying to keep in mind my clients' monetary aspects as well in whatever matters I've been dealing with. And supposedly, a workman or a workforce or a person who comes under the definition of wages approaches you. I definitely am of the opinion that a lawyer should definitely take the case on a pro on a free basis. So.
Yes, even though we are not on the front line as corona warriors, the least thing we can do is give something back to the society. So I'm sure most of the lawyer participants here would also agree on this point. Now moving on to the next question. Maybe with this question we will wrap, and since we are getting a lot of questions, we will move on to the other segment as well. Employers' office EMI versus salaries and wages. Which one should be given priority from the point of view of the owner?
Thank you for this question. But obviously, from the point of view of the owner, one definitely sees his own needs first, and then thereafter he can cater to the needs of other people working with him. So obviously, in order to sustain a business, in view of keeping in mind how an owner will approach the situation, he'll definitely take up his own EMIs as a priority, and thereafter then cater to the livelihoods of work people working with him. But definitely, I like to say that on here once again there could also be a balanced approach in the said scenario, wherein. A futile promise may not be given to a workman or a workforce or people working with you. Definitely cater to your EMIs first, but thereafter have your workforces working with you. And if supposedly you cannot pay for them at the moment, do not terminate their agreements. Maybe they can be advised that after a few days they can come back to the employment once the situation is okay, and have a very comforting and a harmonious approach towards the same, which I feel is lacking today. So yes.
Yes, harmonious approach is the need of the hour. Yeah, quickly moving on to the next segment here. We have got a few interesting questions. Without going in for a particular order, I am just asking you the first question. Is invoking force majeure clause on not paying rents in rented accommodations by major corporates justified, considering the huge resources available at their disposal? This is asked by Mr. Rohit. Is involving force majeure clause on not paying rent is justified by these corporate houses, considering the huge resources they have got at their disposal?
Absolutely. Thank you, Mr. Rohit, for your question. So, as per the one of the orders or one of the advisories that I mentioned in my discussion, which was released by the government, where the government did come up and define force majeure and applicability of force majeure in certain conditions. See, we need to understand it this way, that in such scenarios, we definitely can take defense of force majeure, and to that effect, there are certain things that which we may have agreed upon, we may not be able to do them, despite we having certain stores of income, or certain incomes with us, or certain liquidity with us. But we all have our different sorts of hardships at this time, and keeping in view this, even terming people that if they have liquidities or they have income, they have a lot of cash flow with them, uh, and these guys not paying any rent to any corporate entities, would not be really justified at this scenario. In this scenario, and after all, as I mentioned, that right now we're going through a very hard time, and the need of the hour is to go forward with a harmonious construction, with a harmonious approach, in which maybe we can sit down and rearrange our things, or maybe the entity can bargain the contract with such defaulters at this moment, wherein they can have a thing that maybe in the next coming 2 months you don't pay rent, but maybe after 2 months when everything is okay, I'll be charging you with interest or something of that sort. Can be an arrangement which can be planned. So these are all harmonious arrangements that we all can go forward with. So, yeah.
Yes, at the end of the day, it is only about the people. So they need to sit and discuss and do whatever best is possible from both the ends.
Absolutely.
Thank you very much for answering the question. Now, moving on to the next question. It is by our star participant who has been attending our sessions regularly. It is Mr. Yogesh Kulkarni, Advocate Yogesh Kulkarni from Mumbai. In the current scenario, is it necessary to introduce legal provisions relating to work from home in current laws? And also, the basic rights of the employees who are working from home should be, what is your opinion, ma'am? Is it important for us to introduce legal provisions for these matters relating to work from home? What is your take, Ms. Anushka?
Wonderful question, and definitely, I think this sooner or later would be incorporated, or would definitely come as a legislation, or in any part of any legislation, because as I mentioned in the beginning, when we started the question answer round, we are going into a new norm. We are heading towards a new dimension altogether, wherein work from home would be the concept. So now they would have to be, so this work from home concept needs to be organized, of course, because we all know, at this moment, we definitely take some leeways when it comes to work from home. Um, there are many ways in which we can do all sorts of crookeries involved when we work from home, and I'm not targeting anything on this sort, or on this aspect. It's human nature. When we are given some relaxation, human nature definitely at that time wants to, get some more leeway onto that. Whereas on the contrary, when we used to go to offices, physically attend offices, there were certain things which we actually could not do. But now we can watch a movie while we work. I mean, but definitely, when we used to physically attend offices, there are certain people who used to multitask like that also in offices. But at home, it becomes relatively more easier that you can watch a movie on a louder noise. Um, this is just an example, but of course, I think that work from home concept needs to be regularized, as more and more offices and more corporations are, and also if you talk about schools, online education is now the thing, and it will remain the thing in the next coming few years also. If not years, then definitely months. So I feel definitely work from home needs to be regularized. And talking about what all aspects can be done if we plan to regularize work from home, could be probably timely signing in and signing out, or maybe certain uh, interactive websites wherein our history is also the search history on which that we are working, on the medium that we are working. Maybe that search history could be kept on a check or tracked. But definitely this will again entail the problem of your personal information or information being shared. So we have pros and cons, and we have a big debate on this as well. And this could be done and could be dwelt like really it'll be a lengthy discussion, but these are certain things that I feel.
Yes, we have also got other questions to answer. So just taking one particular question will not solve our intention of this webinar. Thank you very much for just touching upon this important aspect, which is going to be the future. And of course, necessity is the mother of all inventions. And I am sure these corporates will be able to quickly take a quick stand on this work from home culture. So moving on to the next question, it is by Mr. Prasun Vashishta, who is also our star participant who has been regularly attending all our webinars. Can an employer pay a salary less than the minimum wages prescribed in the appointment letter in the wake of COVID-19, owing to lesser profits to the company or the institution? So can an employer pay lesser salary?
First and foremost, when we talk about minimum wages, we really don't see any contract in general being signed between the employer and the employee. But in circumstances wherein there are contractual arrangements between such minimum wages being paid to the employees, the stand is that you definitely cannot go ahead and charge less than what is stated in the minimum in the contract as per what the minimum wages would be. But definitely we would have to see this in light to the certain orders or the standing orders functioning at that time of the said industry. And secondly, we'd also have to see that in light if there are certain negotiations being done by the employer and employee in terms to reduction of minimum wages, then of course getting an implied on an express consent, the said minimum wages can definitely be decreased.
Yeah, again, it all comes to trickles down to the employer and employee to decide.
Yeah.
Yeah. Thank you, Ms. Anushka. Now moving on to the next question. It is by Ms. Arpita Prakash. Madam, someone who has just hired in a corporate sector, but their joining is put on hold. Are they legally entitled to get salary?
Very good question, and thank you for raising this question first of all. So as in my discussion, I mentioned that such would be covered under people who are getting money more than 10,000 or wages of more than 10,000. Such persons are not either covered under POW or under the other legislations that we have just seen in my discussion. So for somebody who has just been retained in a corporate with a corporate entity and has been told to either leave because of the circumstances prevailing, my suggestion on this is that definitely your employer would have spoken about the arrangement or the hardships that he's facing, and this entire system of the entire association of you and the employer would be governed by a contract which you had. So you need to see what exactly how your contract is worded, and even if you've got a termination letter, you now need to see what and how is the termination letter worded. If you see somewhere that there is no mention of maybe a force majeure clause, or if you see that there is no mention of any such cutting down of an employment all of a sudden, then definitely you may challenge and go ahead and challenge the same. However, if you've given an express or an implied consent to your employer in terms to that you're okay with this arrangement of he laying you off or something, of he terminating you, then definitely I would say that the employer in this scenario is correct in what he's doing. And also, if the employer was able to explain to you that he's actually facing hardships or the company is actually facing hardships, and that was justified. In such scenarios, with all heavy hearts, I would have to say that in such struggling and hard times, we have to accept it.
Yes, we have to accept it. Thank you. Moving on to the next question. It is by Mr. Ravinder Sachdev. Is there any government pre-approval required before layoff for private organizations and their employees?
Absolutely. As mentioned in my discussion also, for entities who have more than 100 workmen, only those have the statutory obligation to go to the government and notify them about the reason A of their termination or layoff, and B that they are actually terminating or laying off such people.
Yes, thank you. Moving on to the next question. It is by Mr. Swapnil Vyas, who has come for this webinar for the first time, and he has been asking a few questions. But just for the want of time, we will take one single question now. In case of first claim employee, in case of first claim, should an employee must go to the Shop and Establishment Act, should go as per the Shops and Establishments Act, or can he come directly in labor courts for settlements?
So see, on this aspect, it will all depend upon what sort of wages is he drawing. If he is drawing wages under the POW Act or the Industrial Establishment Act, then definitely he would go under the labor courts. But at this juncture, we would also see if he satisfies the definition of being under the SCE Act. So in this case, the former will apply as mentioned in your question.
Yes. Thank you, Ms. Anushka. Now moving on to the next question. I think with this, on behalf of our team, I also request Mr. Digant Mishra to kindly ask only one or two questions, as we have got questions from other participants also. Anyway, we will try to cover your questions to the maximum extent we can. We will be just asking only a few questions from your end, but if you would really like to get answers for all the questions, you can connect with us or with the special speaker. Once the presentation gets over, I'll ask our special speaker to drop an email ID. The same questions can be asked to her, and she would be very glad to answer your questions. This is an interesting question by Mr. Digant, and he's telling he's a student. He's a student of BA LLB 5th year from University of Pune. In this current pandemic, how laborers and workers can now uplift themselves to overcome this situation. And furthermore, as government has prohibited labor laws in this pandemic for a short period of time, and violation of fundamental right was also, no, there is no violation of fundamental right. Anyway, we will stick on with this question itself. In this current pandemic, how laborers and workers can uplift themselves to overcome this current situation.
Definitely.
So what is your take? Yeah.
Digant, I personally know him as well, and thank you for your question. And definitely, I think maybe after the webinar, we can have a good detailed discussion on your other remaining questions. However, in terms to how laborers can uplift themselves in such times of pandemic is something which I had already mentioned in my discussion throughout. We have many options and many remedies. First of all, if there is any contractual obligation in terms to an contract between both of the employer and employee, definitely the first thing is that the laborer, they all need to stand for their own rights, be it a workman or be it somebody who's getting wages under the POW Act. So standing for one's right is the first and foremost thing of how to uplift oneself. So once you do that, you understand what are the remedies and what are the legal rights that you have with you. So then thereafter, the said person aggrieved would need to see if he is under a binding contract with the employer or not. And if he is, then definitely such a layoff or a termination, an abrupt layoff and a termination is not justified. Thereafter, there are many remedies in today's time which are pro-laborers or pro-workmen, as I mentioned, like certain helpline numbers or COVID helpline numbers. And also there are labor courts which one can approach to, and also there are many lawyers today who they can approach to, who are giving services for such employees on a very generous consideration. So these are all the things in which the employee, the said aggrieved person, can go forward with, and by doing so, one definitely uplifts oneself.
Yes, thank you, ma'am. We will just ask, take one more question from Mr. Digan. Laborers and workers who are financially weak, how can they access the legal help, and how they can know their rights at the same time, who are not who are not knowledgeable regarding the legal aspects. So he, yes, please continue.
Absolutely. I understand your concern very well. And now that when we talk about people who are drawing wages, or people who are under the terms of who come under the definition of workmen, definitely they are facing a lot of hardships today. And to make them understand about what rights they have is the biggest challenge. But with the government initiatives happening around, and also not only the initiatives happening, in the way in which the government is advertising these initiatives, they make sure that even such laborers or workmen or aggrieved employees do definitely are aware about what exactly are their rights and obligations in the present time. For example, the COVID helpline numbers for aggrieved employees have been in the rural sector been given very good publicity. So it's more upon how the government and obviously upon us as to if how we can educate certain people maybe in our community, and we can advertise things which we know of would definitely help to mitigate such problems. So I think this is the end of our questions, or would we miss? I
Yeah,
would.
is it audible now? Yeah.
Oh, yeah, you're audible.
Yeah, with due respects, I would like to take liberty in answering the one question which Mr. Digant has asked. It is a quite interesting question. In this situation, does ITR play an important role, or it should be stopped due to lack of financial flow in the employer's account? That is a very good question, Mr. Digant. I take this as an opportunity to answer your question, since I am specializing in tax laws and I have been practicing this for the last 8 years. There are always two sides for a coin. Just from the point of view of employee, just for this thing, if you are stopping filing of returns, ITR in the sense I consider it as income tax returns. Just if you stop income tax returns filing, or for that matter, the entire income tax as a whole, the entire machinery will not get benefited out of it. ITR not only plays an important role in getting direct taxes and collecting revenues, but it also acts as an important process of collecting data from the assessees. So even at this point of time, it is also equally important for the government to know who are all the people who have gained in this particular period, or who are which industries have benefited or who have achieved more profits during this lockdown. So it is also equally important for them to assess who are all the people who have faced major losses in this particular pandemic also. So this ITR filing acts as both revenue collection mechanism and also as a process of collecting and assimilating data from the point of view of income tax department, which comes under the Ministry of Finance. And I really appreciate Mr. Digant for asking so many questions, and I am sure he would like to connect with our special speaker after the session, and I wish him a bright future, and I request him to join our legal fraternity soon. All the best, Mr. Digant. Now, I would just like to clarify Mr. Parva's question. Yes, sir, you will be getting your certificates, and it will be reaching you by tomorrow. And I would definitely like to connect with you after the session gets over, sir. We have got one last question. I think one more last question before we wrap. Yeah. We have been talking only about employees, but what about the employers who are suffering because of the lack of business? Mr. Krishnan, I think our special speaker has widely covered this particular topic anyway. Just as a wrap up of your speech, I would like to just get this answer in less than 2 minutes, ma'am. Over to you.
Definitely. Thank you for this question. Mr. Anand, before we actually connected over this webinar today, he did tell me as to making my discussion to be not only employee specific, but should also be something which is based upon employer specific. And I have tried my level best in terms to highlight all the aspects and from all the legislations wherever we can take due shelter, either be it from the employer perspective or the employee perspective. Having said this, if you would recollect in my discussion, I did highlight upon, I definitely with due respect understand that not only the employees but the employers are also facing a lot of hardships in today's time, in which businesses are at standstill and there is no revenue generation, and also the market that they were depending upon, the market is also on freeze, which I definitely highlighted in my discussion today. Having said this, there are different options in which the employer definitely can take cognizance into in terms to reduction of wages or maybe retrenchment, which definitely have a legal backing under the Industrial Disputes Act, as I mentioned. For that matter of fact, layoffs also has a legal backing in the Industrial Disputes Act, as I mentioned. So analyzing all these aspects and also seeing whether your workforces fall under the category of wages or they fall under the definition of wages, you definitely have these remedies if you feel if the employer feels that he cannot cater to the situation as of now. And also, needless to mention, I definitely in my discussion emphasized on the force majeure clause. If we talk about relationships, the contractual relationships in which the employer-employee relationship is actually bound by certain contracts. And I also I made everybody understand that the contracts can either have a force majeure clause or the said contract a situation in which there is no force majeure clause also. So in such circumstances also the employer can take effect and can take shelter of such force majeure clauses and terminate contracts based on the said contractual arrangement. And if not, if there is no force majeure clause, then also doctrine of frustration as under the Indian Contracts Act comes into the help of the employers during such outbreak of pandemic and cessation of work. Having said this, the advisories that were issued by the MHA that we have seen were not really binding on the employers, and the employers they were not bound by that. But thereafter, the order of 29th March, which now of course stands repealed, did have mentioned that the employers are bound to pay full wages. But in terms to when employers cannot possibly go through such extent, then comes into the picture of all the aspects that I have discussed in my discussion today and summed up them a little succinctly in my best of my capacity. And yeah.
Of course, you have covered it in an elaborate manner also. Thank you very much. And once again, you have touched upon that very delicate matter of employer and employee rights and responsibilities. Of course, when it comes to the matter of rights and responsibilities, our law says it is equal for both the employer and employee. There is no discrimination whether he is an employee or an employer. Both of them get the same equal rights and privileges. Anyway, I would like to sum up this session's wonderful session. Thank you very much. You have touched upon most of these points which all of us are having doubts in this current situation. You have covered upon the employees' rights and responsibilities, employers' rights, privileges, and what are all the things which he can invoke at the time of this pandemic, and also upon the briefly touched upon the Shops and Establishments Act, then upon the contractual obligation that he has entered, then the workman compensation, and also about this one question which you have answered about the employment which has been kept on hold. So I think you have covered a wide spectrum of questions also, and you have answered them in a very lucid manner for all the participants to understand. Considering the wide participation from all these people, I take this opportunity to thank our special speaker. And yeah,
it was wonderful collaborating also with you, indeed.
Yeah, thank you. Same here. And with this, we wrap this session. And I wholeheartedly thank our special speaker for this detailed explanation. And I also thank all the participants today who have been very interactive throughout our sessions and who have asked all the their questions in a very elaborate manner. And I thank all of them. And as I mentioned earlier, today we have received participation from across India from Kashmir to Kanyakumari, from northeast to east, west, south, north, northeast, from all parts of India. I thank each and every participant, and I also request them to continue and give their support in all the future webinars also. And we also have more exciting webinars coming up in the next weeks, and all the information regarding the same will be posted in our FB page and also in our YouTube channel, AP Legal Chambers. I request all the participants, those who have not subscribed already, to subscribe to our channel to be the first person to receive the videos and also about the updates. I pray for the speedy recovery of all the patients who have been affected due to this corona, and at the same time I also pray for the speedy recovery of the businesses and industries which has because of this corona, which has taken which is in a very bad shape, to recover soon and rise and come to terms with the normalcy. So with all these points, I wrap this session and I thank you all once again. And it is Anand signing off on behalf of AP Legal Chambers and on my personal behalf. Thank you. Have a great day. Have a great weekend. Thank you all. Yeah. Yes.